Hello everyone. Tonight, we're going to step away from the comforting rhythms of village life and the clang of the battlefield, and instead peer into a truly fascinating, often stark and deeply human aspect of the Middle Ages, the world of justice and law. Forget the crisp uniform blue of a police force, the meticulous precision of forensic science labs, or even a single consistent legal code stretching across an entire nation. Tonight we'll imagine how ordinary people navigated disputes, faced terrifying accusations, and ultimately received judgment in a time when the scales of justice were often made of rough stone ancient custom, and the terrifying, unpredictable hand of fate. A patchwork of rules. Where did law truly come from? In the Middle Ages, the very concept of the law was not a single unified system emanating from a central, all-powerful government. Oh no, it was far more complex than that. Instead, it was an intricate, often overlapping patchwork of customs and competing authorities. Can you even begin to imagine living in a world where the very rules governing your life changed depending on who your immediate lord was, where your tiny village was located, or even whether you were a cloistered priest or a sun-baked peasant? It truly was a fragmented legal landscape. Firstly, there was customary law. For the vast majority of people, especially in the countless scattered villages, daily life wasn't governed by written statutes, but by unwritten, ancient customs passed down, generation by painful generation, through oral tradition. These were simply the traditional ways of doing things, how land was farmed and shared, how nagging disputes between neighbors over a boundary line or a wandering chicken were settled, what was universally considered fair or unfair. These customs, often deeply rooted in practicality and the immediate needs of a self-sufficient community, were understood instinctively, a social contract known to all. Then came feudal law. This was the very tangible law of the lord, fiercely enforced on his specific domain, his domain. The lord himself, or more often his appointed bailiff, or steward, held court in the great hall of the manor, overseeing everything from minor arguments over stray animals, rooting up crops, to more serious crimes committed by his tenants. His authority, derived from his grant of land from a higher noble or the king, was paramount and absolute within his territory. To defy him in his own court was to risk everything. And let us absolutely not forget the mighty church law, or canon law. This was a comprehensive, highly sophisticated legal system that governed the clergy themselves. All moral offenses, the sanctity of marriage, matters of inheritance, and even certain types of contracts. The church had its own elaborate courts, often far more organized and efficient than secular ones, and its spiritual punishments, like excommunication, could be more terrifying and devastating than any earthly jail sentence. To be excommunicated was to be cut off from God, from your community, and from salvation itself. Finally, gradually, almost imperceptibly emerging, was royal law, often simply called common law. This was the king's justice, slowly, patiently extending its reach across the entire realm, gradually overriding local customs and challenging the absolute power of feudal lords. As kings grew more powerful and centralized their authority, they sent out their trusted traveling justices to ride circuits, bringing royal justice directly to distant shires and challenging local autonomy. This was a slow, often violent, centuries-long process, but it laid the fundamental foundation for the modern, centralized legal systems we recognize today. Can you imagine the underlying tension as these different legal systems sometimes clashed, each claiming ultimate authority over the very lives of medieval people? Justice at your doorstep, the manorial and village courts. For most common folk, justice was an incredibly intimate, local affair, handled directly in the manorial court or village court. These sessions were typically held in the Lord's Hall, or even more simply, under a great ancient tree in the village square, perhaps every few weeks or months. These weren't about dramatic courtroom battles with eloquent lawyers. They were about maintaining essential order, settling community disputes swiftly, and ensuring the smooth running of the manor's agricultural life. Imagine the scene unfolding before you, the Lord's bailiff or steward presiding, listening patiently, or perhaps impatiently, to grievances. A farmer might stride forward, red-faced, to complain bitterly that his neighbor's unruly pigs had rooted up his precious crops, or two villagers might passionately dispute the precise boundaries of their fields, a conflict that could escalate into a bitter generational feud. Minor assaults, petty thefts of food or tools, and breaches of age-old custom were all handled here. Punishments were typically practical and swift: a fine, an order to laboriously repair damage done, or sometimes a public humiliation designed to shame the wrongdoer into conformity. This might involve being put in the stocks or pillory, a crude wooden frame used to secure a person's head and hands or feet, leaving them utterly exposed to the ridicule and rotten vegetables of their neighbors. This public shaming served as an incredibly strong deterrent in a close-knit community, where one's reputation and honor were quite literally everything. There were no professional lawyers to argue your case. You presented your own story, often relying heavily on trusted witnesses from your community to vouch for your character or the specific facts of the matter. The strong emphasis was always on the restoration of order, the preservation of community harmony, and fair compensation for damages, rather than strict, abstract legal precedent. The Church's judgments, courts of conscience and divine intervention. The church courts held an immense and often terrifying power, overseeing matters of morality, faith, and the very soul. Imagine someone accused of grave offenses like adultery, blasphemy against God, practicing witchcraft, or breaking a sacred oath sworn on relics. These deeply spiritual cases fell squarely under the Church's jurisdiction. Crucially, clergy members themselves, regardless of their secular lord, were also judged exclusively in these church courts, a powerful testament to their independent authority. The Church's power was not just spiritual. It could also levy heavy fines, order public penance, or even, most terrifyingly, excommunicate individuals. This was a horrifying prospect that cut a person off from the community, from receiving the sacraments, and most importantly, from the very path to eternal salvation. One of the most striking, and to our modern minds, truly bizarre, aspects of church justice was its reliance on trial by ordeal. Imagine a man accused of a crime, swearing his innocence with every fiber of his being. To prove it, with all eyes upon him, he might be forced to grasp a red-hot iron bar or plunge his bare hand into boiling water. If, after 3 days, his hand showed no sign of blistering, or healed cleanly in a miraculously short time, he was deemed innocent, as it was believed God had provided a miracle to prove his truthfulness. Another common and equally terrifying ordeal was trial by water, particularly used for accusations of witchcraft. An accused person was tied up, often weighted, and thrown into a body of water. If they floated, they were considered guilty. If they sank, they were innocent. These were terrifying, seemingly arbitrary methods, profoundly believed to be the direct, undeniable judgment of God himself, used in the stark absence of clear, tangible evidence. They reflected a deep, unwavering medieval belief that divine intervention would, unequivocally, reveal the ultimate truth, no matter how cruel the method seemed. The king's expanding reach, royal courts and common law. As the Middle Ages slowly but surely progressed, especially in England, kings began to establish a far more centralized system of justice, a crucial move to assert their ultimate authority over the often unruly feudal lords. This slow but powerful shift led to the development of common law, a revolutionary concept, a body of law that was common to all freemen in the kingdom, gradually overriding fragmented local customs and feudal decrees. The king's trusted traveling justices would embark on arduous circuits, riding from shire to shire, bringing royal justice directly to distant towns and villages. Imagine these learned, often imposing men, always accompanied by armed guards for their protection, arriving in a local town, setting up court in a public square or town hall, and hearing cases that were deemed too serious or too complex for the local manorial courts. This was a crucial centuries-long process, but it inexorably laid the fundamental foundation for the modern, centralized legal systems we recognize and rely upon today. These burgeoning royal courts also introduced early, rudimentary forms of the jury. Initially, a jury was simply a group of local men, knowledgeable about the area and its inhabitants, who were called upon to provide information or present crimes to the judge, essentially acting as witnesses or accusers. Later, slowly, painstakingly, they evolved into bodies that would actually determine guilt or innocence based on the evidence presented. This was a truly crucial revolutionary step towards the modern justice system, separating the accusers from the deciders of fact. For serious crimes like murder, high treason, or grand theft, these royal courts would preside, their judgments carrying the full, unchallengeable weight of the crown: crime and punishment, brutality and public spectacle. Crime in the Middle Ages was often a direct, terrifying threat to the fragile social order and the very fabric of community life. Theft was incredibly common, driven by grinding poverty and sheer desperation. Assault and murder were also tragically frequent, often stemming from long-simmering feuds, bitter disputes over land, or drunken tavern brawls that escalated violently. Punishments were typically harsh, brutal, and almost always public. They were designed not just to punish the individual, but to serve as a stark, visceral deterrent to others, and to provide a clear, undeniable display of the lord's or king's authority. There were no long-term prison sentences as we know them today. Prisons were primarily holding pens for those awaiting trial or immediate punishment. Instead, justice was swift and often physical. Fines, the most common punishment, especially for lesser offenses, requiring payment to the victim, the lord, or the church. Mutilation. For repeat offenders or particularly heinous crimes, physical disfigurement was terrifyingly common. Cutting off a hand for theft, blinding for certain offenses, or cropping ears. The aim was not just retribution, but to leave a permanent, visible mark of shame, identifying the criminal forever. Whipping, flogging, publicly administered for various offenses, a painful and humiliating deterrent. Hanging, the most common form of execution for serious crimes, almost always performed publicly on a gallows outside town walls, a grim, stark warning to all who passed by. For treason, the ultimate betrayal of the king or realm, the execution might involve even more gruesome, protracted forms like drawing and quartering, designed to maximize agony and public spectacle. Trial by combat. For nobles or in cases where evidence was incredibly unclear, a trial by combat might be granted. Imagine two armed men, often knights, fighting to the death, or until one surrendered and conceded defeat. The victor was widely deemed to have God's favor, and thus to be unequivocally in the right. This was a brutal but compelling public spectacle, seen as a direct, divine judgment on the matter. The lack of forensics and the quest for truth. Crucially, and perhaps most strikingly to our modern minds, the medieval justice system operated without any understanding of modern forensic science. There was no fingerprinting, no DNA analysis, no ballistics to trace a weapon, no crime scene investigation. Proving guilt relied heavily on fallible eyewitness testimony, confessions, circumstantial evidence that could be easily misinterpreted, and as we've seen, the terrifying, often arbitrary ordeals. The concept of innocent until proven guilty was fragile at best, and certainly not a universal right. An accusation alone could utterly ruin a life, and the burden of proof often fell heavily on the accused to somehow demonstrate their innocence, sometimes through divine intervention, as interpreted by ordeal or combat. Justice was often swift, deeply imperfect, and heavily influenced by social standing, personal reputation, and local power dynamics. The impact on daily life. A constant awareness, this unpredictable, often brutal legal system profoundly impacted every facet of daily life. People lived with a constant awareness of the law's reach, however fragmented, and the severe, often irreversible, consequences of transgression. It fostered a deep reliance on community and on the local lord of the church for what they hoped would be fair judgment. It also meant that many disputes were likely settled informally within families or close-knit communities, through negotiation or mediation, precisely to avoid the terrifying uncertainties and harshness of official courts. The constant, visible presence of public punishments served as a grim, ever-present reminder of the consequences of straying from established norms. Yet for all its flaws, for all its reliance on superstition and brutal force, it was the system that maintained what fragile order existed, shaping behavior, deterring crime, and providing a fundamental framework for social interaction in a world without dedicated police forces or pervasive, modern surveillance. It was a mirror reflecting the harsh, yet deeply faithful realities of medieval life. So as you drift off to sleep, perhaps you can imagine the echo of a bailiff's stern pronouncements, the creak of the pillory in the town square, or the silent, desperate hope of someone facing an ordeal by fire or water. Imagine a world where the scales of justice weighed heavily, often on a knife edge, and the truth was often sought through the unyielding hand of fate or through the sheer might of God as they understood it. Good night.